Hello and welcome to Upgrade Thought. Today I'll be talking with Jon Mazer. Jon is a lawyer who has done all different types of cases, from civil to criminal. Jon has a broad litigation background, representing a wide range of businesses and individuals. Additionally, he studied philosophy both at the undergraduate and at the graduate level. In this episode, we discuss what it is like to be responsible for people's legal situations, how Jon gets his witnesses comfortable talking in front of court, the most serious case that Jon has ever worked on, Jon's perspective on defending someone who might be guilty, how a philosopher used philosophy to critique philosophy, how Jon was able to shock a witness with his niche expertise in front of a jury, what the value of being a well-informed citizen is, and much, much more. Enjoy the show. Welcome to the show.
Thanks for having me.
So first question, you've always wanted to be a lawyer. Why? What attracted you to the legal field at such a young age?
I think the interesting thing about the legal field, there are a lot of interesting things about it, but I think what drew me initially was the chance to look at and improve arguments and make arguments and think about what was convincing, and I think that's what was one of the original things that drew me to it. When I was in elementary school, I can remember that in my 5th grade class, we set up a conflict resolution procedure that allowed, if you had a complaint about somebody else, you could get involved in a conflict sort of resolution discussion, and in that discussion, you could get somebody to help you tell your story, and I was sort of drafted into those proceedings that we had in 5th grade, and that was sort of where I got my start, I guess.
Interesting.
I had several relatives who were lawyers, and so I viewed them as interesting and smart, and admired what they had achieved. And then later, when I was in high school, I participated in our high school's mock trial team, and that I'd wanted to be a lawyer. That's why I decided to get involved in the mock trial team. But the experience on the mock trial team only made that desire stronger, and we had a coach who was an assistant district attorney in Brooklyn who worked with our team and helped us improve our performances during the competitions. And he was also an inspiration because I thought, I was impressed with how smart and how capable and how interesting it was to be able to find out things by questioning people and look at different cases with different perspective, or fact patterns with different perspective, and make different arguments about them. And so all those experiences contributed to my wanting to be a lawyer.
So you were talking about what you did in high school. So then you went to college, and correct me if I'm wrong, but it sounds like you knew the path that you wanted to go down. What did you choose to study, and why?
What I studied in college was philosophy, history, which I double majored in, and I also minored in economics. And I think, you're right that when I went to college, I already had in my mind, what I wanted to do. I was pre-law, and I wanted to major in something that was suitable, for pre-law student, but there's a wide variety of majors that you can get involved in as an undergraduate and go to law school, so that wasn't really that much of a constraint if I'd wanted to major in the sciences or something like that. But philosophy and history and economics are 3 very common majors for pre-law, and I'd had while in high school, chance to study those subjects. Even as a high school student, my high school permitted the students there to take courses at the local college, which was Brooklyn College at that time. And I took a course at a very interesting philosophy course, at a very interesting economics course, which they didn't really teach in my high school. So I got exposed to those before college. And even when I went to college, I said, I really want to learn more about philosophy. It was really interesting and exciting what I'd learned, taking class at Brooklyn College as a high school student. And so I had that in my mind, and I was very interested in history. And I also became very interested in economics from taking a class at Brooklyn College, also as as a high school student.
Yeah. So I was just curious, why are history and economics typical classes for pre-law students to take? Like, how exactly does it end up translating to the legal field?
Well, that I'm not 100% sure of.
But you were interested in it, so you wanted.
I was interested in it anyway. But I think just based on my experience, I'm now almost 30 years as a lawyer. Based on my experience as a lawyer, it depends also on what you decide to do as a lawyer. I've been involved in litigation during the period, that I've been working as a lawyer. Litigation involves a lot of instances of looking at primary documents, people's emails or their business records or video evidence or other kinds of primary documents and evidence, and describing a factual narrative based on this material. And so that's a very big part of litigation, and then making arguments and saying what logically follows or what follows under precedent from that analysis of the primary documents and the factual story that results from that analysis. In many ways, that bears a striking resemblance to the work of historians, I think. And so there's a big, in my opinion, overlap. With the history major for sure. Philosophy is also, like law, a discipline concerned with exploring and strengthening and making more powerful arguments about a variety of subjects, while philosophy tends towards the more theoretical, and law sort of angles in many instances towards the more practical, although there's plenty of exceptions to both of those, to those things with respect to both of those disciplines. Both disciplines concern the strengthening and improvement of arguments and overlap a great deal. So I think both of those disciplines in particular are very good preparation for law school.
So which philosopher did you resonate with the most? Did you have any favorites when you were studying philosophy, favorite people to read? Or
so like a lot of fans of a discipline, I'm hesitant to identify one, name one as a favorite. But, when I took the class in Brooklyn College that I mentioned before, where I got my first sort of exposure to philosophy, we looked at Jeremy Bentham and John Stuart Mill and the utilitarian school of thought. That was, I think, the first thing, or one of the early things that really caught my interest. And then later I studied to some extent Peter Singer, who drew out the sort of implications of utilitarian thinking in a practical situation, and I found that very interesting, how he took something theoretical and he applied it to a practical situation. Our interaction with animals is the part I'm talking about. He's written about a lot of different things, but that's the part I'm thinking of, and I thought that was a very sort of interesting thing to be exposed to, to the application of these concepts to the practical world. In terms of social theory, I got interested, in, it was actually what I would say a philosophy class, but in my economics, I was an economics minor. This was part of the economics coursework, but it was a class on the sort of philosophy of economics, so it was a kind of crossover class. We studied, among others, John Rawls, who gave very interesting explanations of the justifications for setting up society, how society should be set up and whose interests should be taken into account and how they should be weighed. And I thought that was very interesting. I also, in college and then in graduate school, I attended graduate school for philosophy, where I obtained my master's. In addition to going to law school, I studied and after that, since then, and before then, to some extent, I looked at Bertrand Russell and Ludwig Wittgenstein, both of whom I found very interesting. I struggled with some of Russell's more complicated technical work that he did on mathematics, but he also wrote, and I was impressed with, his ability to shift from complicated technical parts of philosophy to history of philosophy, history of ideas, and more introductory kind of more generally understandable discussions of politics and political philosophy and the nature of mathematics and the role of religion and why or why not, religious ideas are convincing. And so those were some of the things that I was interested in with respect to Bertrand Russell, who I spent a lot of time studying. And Wittgenstein, I always found to be an interesting character, both personally and in writing. He had several phases in his career. And in an earlier phase, while he was a prisoner of war in Italy, he wrote a book, that became a leading discussion of in logic and broader issues in philosophy. That was a very, I thought, elegant, concise, interesting book that looked at 7 different propositions, and then at the very end sort of tied the whole thing together in a few pages in which he explained why philosophy, as it had been practiced up till that point, was fundamentally flawed and, in a sense, pointless. And so that book sort of explained the entirety of philosophy very briefly and concluded with a distinct conclusion at the end about the value of that discipline.
Why did he think that the way we had been practicing philosophy was useless?
Because what he thought was that philosophical questions as they'd been conceived up till that point were the result of the misuse of language, and that by asking unanswerable questions, we got ourselves into a pointless quagmire.
Like a semantic...
Right.
Okay.
And so that he said, if a question can be asked, so too can it be answered. And that the questions we were asking in philosophy got us sort of into an endless loop, because they weren't meaningful questions, even though they were in the correct grammatical form. They mixed concepts and failed to be meaningful, and as a result couldn't be answered, and as a result philosophy itself was being practiced in the wrong way.
So it just became an endless, unsolvable riddle, basically, as opposed to a meaningful inquiry into important questions.
And one ironic aspect of this is, in order to get that explanation across, he had to engage in the very same methods that he proved were not valid. And so
do you think it sort of bit its own tail, or was he able to do that successfully?
Well, I think saying it bit its own tail is a kind of apt analogy, because the way the book ends, he says, what we cannot speak of, we must pass over in silence. But he had just spoken of these very things to, seemingly persuasive effect. And so if his argument was correct, it proved his argument was not correct. And so
he philosophically reduced the importance of philosophy.
That's exactly right. And so that was an interesting and elegant book, was widely discussed at the time and since. In fact, has been also in its sort of holdings widely rejected, including by Wittgenstein, but is still studied in great interest. But he then created a whole second school of philosophy that involved an analysis of, sort of looked at language in a different way, and looked at language as language, to use an analogy he used, language games, that created a whole different school of philosophical thought that then, so he sort of in his career was someone who wrote very few books. He wrote one extremely elegant book, he wrote a couple of other things, but most of what passed for his writings that you can get today involve little notes that he took that were then formulated into books and other publications by his literary executors after his death. During his lifetime, though, he was widely recognized, despite this thin publication record, as one of the greats of philosophy, and held court and had scholars from all different disciplines, attending his lectures and hanging on his every word.
What was his name again? I'm sorry.
Ludwig Wittgenstein.
Okay, got you.
And he also has an interesting biography in addition to all of that, a sort of separate discussion. And so that gives you, I think, a little bit of a survey of some of the people I've been interested in over the years, on and off.
Nice. So we were kind of talking about this earlier, but how are you able to deal with the pressure of having people's legal situations in your hands? Like, what's that like? Is that like, talk about your experiences there?
Well, first of all, it's a huge responsibility. It's a situation where you're placed in a position of trust, and the person who's retained you is relying not only on your intelligence and your ability to analyze legal problems or advocate, for them with respect to legal problems, but also your remaining on point and being there when the crisis or when the issues that they're facing become crises. And so, it's a sort of multi-tiered process, that involves one, relating to the person, building a relationship of trust, and a sort of intellectual component of finding out about their problems, developing solutions to them, based on precedent and other legal sources, and advocating for them at the right time. And so it's a huge responsibility, and if you take it on, it's something you have to be dedicated to improving the situation of your clients if you decide to take it on, if you decide to take on a representation.
Is it ever, well, I guess my question is that ever a challenge to like kind of represent people in good faith who may have, you think it's possible that they might have done something wrong or, something of that nature? Like, let's say you have a client who, for whatever reason you think might have, actually committed the crime that they're being alleged of, or they're being accused of committing. Like, is it a challenge to represent them in good faith, or like how do you sort of navigate that, conflict, so to speak?
Well, so let me, I think there's two levels on which the question you're asking can be addressed. And I'd like to sort of set aside, I'd like to take your question first and give you one answer to it. Then I'd like to take your question and make it a little more difficult and try to answer that question.
Okay.
So let's take the easy part first. When you say, do I have a problem representing someone who's done something wrong or maybe is guilty of the offense they're charged with, the answer to that, is definitely no. And one reason, in the broad sense, and one reason why that's the case is because even someone who, let's say you ask, am I comfortable representing someone who's guilty of, a crime? And I know they're guilty. Well, of course I would still represent such a person, and potentially, and such a person still needs representation and should have representation. For example, suppose someone is charged with a crime and admits doing that crime. Then the next phase, so maybe the prosecutor and the judge also knows he did it or the person did it because he's admitted it. It doesn't follow from that the case is over, because other things may happen in the case. So if someone admits to doing a crime, you go to a phase, for example, I'm not doing that much criminal work at the moment, but I'm mostly doing civil litigation, but I've worked on criminal cases many times in the past, and I think it makes it easier to answer your question in that context. But that person then would go on to a sentencing phase. And so, for example, the laws with respect to sentencing, there may be an argument about that. Someone say, well, if you're guilty of this offense, then you should get a 4-year sentence. And it may be, well, judge, there's another part of the statute that says if you're guilty of this offense and you have pointy elbows, you only get a 3-year sentence. And so even the person's guilty, there may be some reason to say why some argument being made about how he should be sentenced may still not be correct. Or, for example, there may be a rule that says, if someone's sentenced to 5 years as opposed to 3 years, they should be within a certain distance of their home or their family so that it facilitates family visits and makes it easier after the sentence for that person to transition back to their family and back into the community. And so that may be a goal of the law, and that may be there in the law, but if the prosecutors or judges are not aware of that, that person's advocate has to bring that up to the judge and say, Judge, you should not sentence him to a facility, 2,000 miles from his house. You should sentence him to a facility, to serve out his sentence that's within 100 miles of his house. And here's where it says in the statute that you should do that. So in answer to the broad question, can you represent somebody who's guilty, who's done something wrong? Well, the question of guilt or innocence may only be one question. And so there may be many other aspects of it that require advocacy, on which the cause of justice is best served by that person having an advocate who can promote other aspects of their situation that are legally significant apart from guilt and innocence. So that's one point to make. So even the guilty, even people who've done something wrong, they still have rights that need to be addressed, that may be totally unrelated to guilt or innocence. So they still need advocates, and it's still right and proper and just, and you can sleep with a clear conscience in making their arguments. Now, to try to address what I think may be on your mind, that I think is a sort of more difficult version of your question. With respect to somebody who you have reason to believe, or convincing reason to believe, or you yourself are convinced did something really wrong, did the thing they're charged with, and you have the opportunity by making procedural arguments or by presenting some evidence that that may contradict their guilt, even though you don't find it convincing, that you might have the chance to get them an acquittal. And that presents a sort of more significant challenge, because now we're talking about helping them to address the specific thing that they've done wrong, and to try to get a ruling either from a court or from a jury that they're not liable for that thing that they did wrong in any way, sort of shape or form. So if you can get somebody an acquittal for a crime they've committed, for example, you will know in your heart that, or your belief that somebody guilty was set free partly as a result of your work. And then the question becomes, are you comfortable with that? And, the answer that I give to that is that that's more challenging than the easy version of the question. Mm-hmm. But nonetheless, it's the case that in our system, somebody shouldn't be imprisoned or shouldn't be punished for a crime unless there is a public proceeding where they have access to a public proceeding in which they have the right, for example, to present witnesses in their defense and present evidence in their defense. And only after that is their guilt convincing. The fact that I may have reason to know about their guilt based on, or formed a belief about their guilt based on evidence that I have that may not be presented in a public proceeding, that I think that alone is not enough that they shouldn't have a good defense, because the system will not function correctly if defense lawyers are making these determinations themselves. In that case, we wouldn't have the public record and the public proof. And if it's the case that the prosecution can't prove the guilt, even though the defense lawyer may believe it's the case that the person is guilty, presents a real important question for our society whether such a person should be convicted, and the decision we have made socially about that is that such a person should not be convicted, and that has a negative effect on the broader system, and that to preserve the broader system in which people's rights are protected and the innocent are protected requires in some instances the guilty to get a benefit that perhaps in some moral sense they're not entitled to.
So the idea is basically that you have a job to do in a broader system, and your job is to give this person the best representation that they can get. And, on the small micro scale, sadly, the way our system is set up is that at times that might result in, someone who's done something wrong getting away with it. But on the more macro scale, you participating in that system makes the system function the way that our society has, intended for it to work, basically.
Yes, and when I got involved in this profession, I made a commitment to uphold the Constitution and act as an officer of the court in working within that system. If in a specific case I become uncomfortable with it for personal reasons, the solution is not for me to subvert the system, in my opinion, the solution in that situation would be for me to request permission to be excused from continuing that representation.
Interesting. Okay. So I was also curious about persuasiveness. So talk about the role of persuasiveness in court. Have you ever been able to leverage your persuasive ability so much in a case that the ruling might not have been accurate or moral? So kind of on the point of our last question, like, have you had experiences, presenting a story in such a compelling way that, like, perhaps it skewed the decision? Like, talk about that.
So it can be the case that you get a result that, in a case that seems to be beyond what you think the client might have been entitled to. That can be the result of a variety of things. One thing can be you're being extremely persuasive. Another thing can be sort of a lack of effort on the other side sometimes. And so you might put on the same level of persuasion on some occasions, on one occasion as another occasion, but the better, more experienced advocate on the other side, or there may be some lack of preparation on the other side, may result in a very different outcome. So sometimes you can be so persuasive as to persuade beyond what you're entitled to. That can happen. And sometimes you can be average persuasive, but the other side, or whoever you're against, has not come to court with their preparation, adequately completed or adequately done, or they're particularly unpersuasive or particularly unmotivated, maybe because they're not being paid or the amount at stake is not that great. And so sometimes you can outpersuade the other side either by the force of your own skill or sort of luck of their lack of skill or lack of preparation, and get an outcome that seems to be beyond what you would have thought would have been the thing your client would have gotten.
Do people come unprepared to court? Is that something that happens? Is that something that happens frequently, or is that an extremely rare instance? Is it common for a lawyer to show up unprepared? Does that happen?
It can be quite mixed, and certainly there's plenty of instances where lawyers show up unprepared, and sort of try to pick up what they can when they're there and make arguments based on that.
Wow.
Or for one reason or another, despite effort to come to court prepared, can't because the evidence became unavailable, or the client failed to cooperate, or either by inclination or lack the ability to cooperate, or some other impediment to your getting the case ready, when it should be, including just a lot of cases piling up at the same time sometimes. So yes, I've seen plenty of lawyers show up unprepared. It's not that uncommon.
Wow. Okay.
I'd make a strong effort to avoid it myself.
Yeah. Fair enough. So you're a very persuasive person. So what are the components that go into being persuasive? Is it just being able to present the evidence in a compelling way, or does persuasion extend past, just logic? Are there emotional components? Basically my question is, how far past logic does being persuasive extend?
Well, so there's sort of, I think, several questions there to unpack, but there's logic is one aspect of it, but I think in being persuasive, there's at least two other aspects. One is the preparation. So in order to persuade somebody of something, and a lawyer, in the form of a sort of legal argument that takes the form of my client should get this or that outcome, usually has two main components. One is, what is the factual input? So what factual thing happened? And two is, what are the rules with respect to that type of situation, and what outcome should be reached in that type of situation? So I think being persuasive before you make your argument, you have to look both at what are the facts, and what are the rules that apply to facts of that nature, and you have to go backwards and forwards between those two things, learning usually first some of the factual information, then looking at the rules and the laws and the other examples, and getting ideas for, where can I go back to the factual investigation and say, okay, here are some precedents or some other cases where something similar happened, but these precedents also had another component. The person had curly hair, or the person did whatever they were claiming, they were entitled to a reward for on a Tuesday. Let me go back and conduct a further investigation and find out whether the person I'm representing also has curly hair, or do they have straight hair, and is it different? Did they do their thing, whatever they're claiming, on a Tuesday or a Wednesday, if that's relevant, and so you go back and forth between the factual information and the rules that apply to those kind of facts, and you go back and forth between those two things until you find, and I think by going back and forth between those two sort of categories, that's where you find the sweet spot in persuasion. And then once you sort of have that, then it's a matter of creating a way to present that to the decision maker. And I think, in law, these are typically presented in written presentations in writing, as well as oral presentations in verbal argument. And, both of these are skills that can be practiced. And so if you want to make a verbal argument, if you're doing writing, writing is a skill that takes time to develop. And the better developed your writing is, the more persuasive you'll be able to present, the better you'll be able to present concisely, powerfully, the most persuasive points that help your client. And, with respect to the verbal part of it or the oral argument part of it, that's something that can be practiced. And so through meticulous examination of the facts as applied to the relevant legal principles, and then careful writing and rewriting, as well as practicing your verbal presentation, I think these are the components, broadly speaking, of what makes a lawyer persuasive.
So when you talk about the rules that apply to certain facts, are you talking about specific rules in court as far as how to apply, how you, I guess, present the information, or were you more so saying being relatable to the jury or the judge or whatever? Is it talk about that?
Well, sure. So the rules I was talking about, involved primarily, could involve a variety of things, including government memos and other things. But the two main sources are statutes, meaning laws that have been passed that purport to prescribe or set forth rules, and cases where similar fact patterns have been presented to courts, and the judges or courts have written decisions that explain how statutes or other rules are being applied to specific fact patterns. And so those two components, the so-called statutory law and the decisions, which is the so-called common law, taken together provide the two sort of main sources of the legal rules. And that's mostly what I was talking about, although there are other legal authorities that might apply in specific situations, like for example, memo written by authoritative agencies with respect to a specific topic might be an important source of law. But so that's the rules I was referring to.
Okay.
With respect to the role of emotion and other aspects of presentation, they certainly are pertinent. And for example, I sit here with having this interview, if you present this podcast, in video form, your viewers will see that I have long hair. So, if a lawyer shows up with long hair or a scruffy suit or a press suit and short hair, that may make a different impression on decision maker for one reason or another. And whether that's just or unjust, it should be taken into account and accounted for in representing clients. And it can be taken into account, accounted for, sometimes by maybe changing that appearance if that seems to be the best strategy under the circumstance. Another way it can be taken into account is by being upfront about it with the decision maker and saying, judge, or jury, Mr. Smith, who's arguing for the plaintiff, presents in a well-pressed suit. I present, a little bit more scruffy. But I'm asking you, ladies and gentlemen of this jury, to focus on the evidence and to consider not our appearances, but our arguments. And here's my argument with respect to the evidence, and I'd like to talk to you about, each witness that was presented in this trial, each document, and explain to you why I believe it supports the outcome I'm asking for here. And I'm asking you to look past our appearances or look past our speaking styles or other aspects, and focus on that evidence. And so sometimes by bringing it out and embracing, some aspect of it, even if you think it might abstractly cut against you, sometimes, that aspect can be addressed that way.
So there are ways that you can kind of slide in an emotional appeal to certain jurors. When you're conducting the case or when you're presenting the evidence, you can, keep in mind that they might relate to certain points that you make, or you kind of you resonate with certain things that you say if you kind of, present it in a, emotionally appealing way, would you say?
So I was involved in a case at one point in which somebody received minor injuries was involved in it wasn't exactly a car accident. What had happened was somebody was brought somewhere in a livery vehicle, not a taxi, but a different type of livery vehicle. And the place he was dropped off, there was a place where it wasn't dropped off in a safe place because there was a ditch right near when you had depression or a change in the concrete that he tripped on. And so he ended up suing a variety of defendants in that case. He was injured, and then eventually he had his legs amputated. However, his legs, it turned out, were amputated for a different reason and would have been amputated anyway. As it turned out...
So that had nothing to do with the case?
It was argued in the case that the need for the amputation was accelerated by the fall.
Okay, I see.
Although that may have been, sort of... attempt to improve the case, by the plaintiff's attorney without justification. But in any case, so the two things are very memorable for me about that case. One is that the plaintiff, who I represented, one of the defendants, who claimed that he couldn't be liable in the case because of his relationship with the driver of the vehicle. So he was named in the case. He had a connection to the driver, but our argument was that the connection of my client to the driver wasn't enough for them to be a proper defendant, and that if there was a remedy for this where he was dropped off, it related to the driver, not to my client, who had a secondary relationship with the driver. But during the case, the person who made the hole in the concrete also was Con Edison, was named as a defendant in the case. And so there were different arguments being made in defense of this case. But, the plaintiff himself, who was a retired physician, was absolutely a charming person. Mm-hmm. Pleasant, interesting. And, we had a chance to take his testimony prior to the trial, and that's how I met him. And I think the consensus among all the defendants was that if this case went to a jury, they would view him as very charming, and that would help his case. Mm. So that was just sort of, everyone accepted that the sort of truth of that in this context, that whether he's charming or not really shouldn't affect the value of his case, but it seemed like it would. So that was one aspect of it. So another thing that happened in the case is during discussions of the potential settlement of the case, the plaintiff's attorney promised that at the trial, that he would take his client's artificial legs and hide them or he would prohibit his client from bringing them to the trial.
Wait.
So that when the plaintiff was called up to testify, it would be necessary for him to get up off the chair and make his way to the witness stand on his stumps with blocks on the floor, struggling to get to the witness stand.
That strikes me as a little disrespectful to the client. Like,
Well, it was really said as a joke, But the point he said,
Wow,
he added, the plaintiff's attorney in jest, and so let's forgive him, and see what the serious point is here. But he added in jest, and, there would be a bloody trail from his leaking, stumps, all the way from the defense table to the witness stand.
So just trying to make a huge scene of this, and
right. And the point I think he was making is that when you have a seriously injured plaintiff, the emotional impact of that on a jury can swamp the defense's view, defense's argument to the jury that, hey, well, there are these legal rules that say, someone in my position really shouldn't be liable, and I know he was badly injured. It's that once, I think the plaintiff's sort of, joke was that once the jury sees, how charming he is and how badly he's injured, they're going to want to make the defendants liable for it, regardless of anything else. And so that I bring this up because I think your question was, what's the role of the emotional impact that somebody might make on the person making the decision. And so here it was, very starkly presented for me that, a sympathetic plaintiff is going to be looked at differently than a plaintiff who's not sympathetic, particularly if he's, elegant and charming and pleasant to have in the room. Just to tell you the ending of that story, the plaintiff passed away a short time before the scheduled trial. He was already elderly.
That's terrible.
And, he passed away for reasons other than anything having to do with the trip and fall accident that he was suing over. But without the plaintiff there to present, you still could have gone forward with the trial by presenting the cold transcript, but suddenly the value of the case was greatly diminished because the emotional impact of it was lost. And so this was something that stands out. I have had many cases in my career that had elements of what I've just described, but this sort of, I think, puts it on the case pivoted, the outcome of the case pivoted around the emotional impact that plaintiff was likely to make in presenting to the fact finder.
Interesting. Huh.
And, there seemed to be among a significant group of defendants, attorneys, because there was the plaintiff's attorneys, and then, as I said, there was sort of two theories of the case. One, the driver and the people related to the driver, and the other theory related to the numerous people involved, and it wasn't just Con Edison, it was contractors that Con Edison had brought in. So there was numerous people involved in creating that hole in the ground that he tripped on. And there were several companies, involved in that, with the result that there was a whole group of attorneys, all of whom seemed to look at this situation in the same way,
Yeah. Huh. So on one side we have, them trying to, dramatize this, I guess, obviously, unfortunate incidents and kind of emotionally appeal to the jurors. Meanwhile, the other side is, presenting evidence as to, this is your side. Yes, this is terrible, but there's not really a good case as to why, our client should be held responsible. But the jury is likely in that. Well, I guess what your point was that the jury could go either way. They might have, they might see the evidence, or they might. What do you think would have? Let me ask you this: if it did happen,
the jury could go either way. But I think if the plaintiff was less charming or had less severe injuries, they'd be much more likely to follow, or go with the defendant's viewpoint on it. And again, it's still a horse race until it's called or whatever. Yeah. But
what do you think would have happened if the trial actually happened? What do you think would have went down?
Again, I think he would have got more than a less sympathetic less charming plaintiff would have got, but he was still a horse race.
Yeah, interesting. So,
but I think it improved his chances.
Yeah. I want to transition. So in everyday life, do you think being persuasive, I think being an extremely rational, think your way through decisions, consider the evidence, for obvious reasons, that can be a huge advantage in life. Do you ever think that it's a disadvantage though? Do you think that being so persuasive ever allows you to make a decision that isn't in your best interest just because you've done such a good job of persuading others or even persuading yourself that it was the right decision, just because you're so good at making a case for something? Or do you think that never happens and you try to just dissociate yourself from whatever the decision is and just consider the evidence in the most rational way possible?
Well, so I think as a lawyer, and in other professions as well, but lawyer is the one I'm familiar with, you're trained to look at emotional situations and try to see the rational aspects of it and give a logical analysis of it, even when it's a striking, the emotional components may be very striking. This is certainly true of physicians. This is true of psychiatrists and psychologists. This can be true of people in the military, for example. And this is true, I think, of a lot of professions. But again, lawyer is the example I'm familiar with. So I think, in most situations, this can lead to better outcomes, but there are definitely pitfalls. And if, two sort of things come to mind. But one is the character, I think, and I'll give you the two examples, but, I just think that sometimes logic can get it wrong in a situation where where the better part of valor would be to have an emotional response.
Yeah, well...
and let me give you the example. Yeah, so in Star Trek, there was a character, and, in the first version of Star Trek, which was produced in the 60s and 70s, so a little bit before your time, although maybe you're familiar with it, was a character played by Leonard Nimoy, actor, called Spock. And Spock was a character who worked on this... a spaceship, that was traveling around the galaxy for a variety of reasons. And what was significant about Spock is that he sort of looked like a human. He lacked an emotional component in his thinking and always gave a logical analysis no matter what the situation was. And you saw it in Star Trek, many instances where he seemed to give an answer that was completely unacceptable to everyone, even though everyone could see the logic of the position. And so there were a lot of, this was a sort of, a TV's attempt to depict this problem that you're talking about. The other thing I wanted to mention in response to this question was a famous story example given by philosopher Bernard Williams. And what he says, in discussion of, there's a series of theories and ideas about, how to treat people justly, and, what someone might be entitled to as compared to someone else when faced with particular circumstances. So some kind of wrongs done to them. But one person is your business partner, and one person's your total stranger. Do you have to treat those the same way, out of some version of equity? And so you could have a theory of equity that would say they have to be treated equally, if they have the same kind of danger that they're facing, for example. You could have some other theory that says, well, you should favor your business partner, in that situation, and here's why, And so you could have logical analysis of this, and you could have problems presented and give a logical answer to these based on these different theories, different philosophies. And he describes a situation in which, someone's on a boat and two people fall off the boat at the exact same time, and you can only save one of them. And one of them's your wife who falls off the sort of one side of the boat, and one of them's the person that's in the cabin, two doors down from your cabin, or you didn't meet, who falls down the other side, and maybe morally you could have an ethical theory that's morally they're equal and they're equally entitled to rescue. You could have that theory. What Bernard Williams says is the person who stops to analyze that before jumping in after his wife to save her, has had one thought too many.
Yeah.
And so logic has its place, emotion has its place, and you can get tripped up by bringing one into the sphere of the other in a way that's detrimental. And so while overall, I'm in favor of people improving their reasoning skills, and becoming as logical as they can, and developing those, flexing that part of their muscles or their brain muscles or whatever. At the same time, if it's applied in the wrong circumstances, it can go wrong.
Yeah.
I have certainly seen instances of that in my lifetime.
Yeah, I mean, this question might be a little tough to answer, but like one thing that I've been struggling with, how do I balance both? Like, how do I know if it's a situation where I need to be just like cold and, just take my emotions out of it and just make the logical choice, or if it's a scenario where, I need to be a little bit more emotional here, and maybe, there are logical points for one decision, but the emotional one, like how do I know when to trust my intuitions and my emotions, and how do I know when it's a situation where, reason should be applied? Like, do you have any thoughts to offer to that problem?
Well, my first thought is that it can be a challenge. And I think that challenge is not going away, and that it's going to be with you for a long time. That said, I think if there's a way to address it, it's to become strong in both spheres, and become well practiced in both spheres, so that you have well-developed relationships of friendship and other types of personal relationships, and well-developed analytic ability, and with both of these skill sets, thought about and worked on, let's hope that the right one emerges at the right moment.
Interesting. Thank you. Yeah, that's very helpful.
Well, I appreciate you being charitable about that.
So, talk about the transition. This is kind of another harsh transition, but you recently switched from working to a firm to being self-owned. What's the transition like?
I would say in general that I had a good experience with it. An organization working within an organization has a number of benefits, including there's more backup and more camaraderie and more collegiality and more ability to discuss things before making a decision. But it has certain negative things. You have less control over your work life. You may have to sublimate or sort of suppress your own preferences or interests to the improvement of the interests of the group as a whole. And you have to comply sometimes with rules or policies that may not suit you in a variety of ways that you view as arbitrary. It may be frustrating at times that you're not the decision maker with respect to certain aspects. But very often, that individuality is given up, in exchange for both a sense of security in in terms of the continuity of the work and so on, as well as, having access to more resources. So when you work in a larger group, there's also often people that you can talk to that have other skill sets that you don't have. And so there's a number of advantages to working in that context. Working on your own had the advantage that you get more control over your life. When you work in an office, you're working in effectively your own space, and you have more control over the decision making and the priorities of the firm and the work. And so there are a lot of advantages and disadvantages going in both directions. In my own specific case, one thing that eased the transition for me was I brought a lot of the same cases. So when I left the firm I was previously working at, even though I was working within the context of a firm, I did have some cases that were my own cases that I was primarily working on, and that was a lot of the work I was doing at the firm, cases where I controlled the relationship with the client. When I went off on my own, those clients followed me, and I continued doing a lot of the same work. In addition, when I left the firm I had been previously working for, another group left at about the same time and set up another small firm, and I'm working with that group, not within the same firm, but in conjunction with them on a number of issues. And so I was able to create some continuity. Mm-hmm. Even though I went off and started my own firm, there was a significant degree of continuity between the work I had been doing before I did that and the work I was doing after, including the people I was working with and the tasks I was doing and the cases I was working on. So all in all, I had a very good experience with it, and I enjoy having, the flexibility that this form of organizing the work gives me, and so I've had a good experience with it.
Yeah, I was also going back to the stuff related to the court case. I was curious to know, how do you get, let's say, a witness comfortable to talk in front of court for the first time? Like, let's say you want to bring in a witness, they've never been in a court setting, they've never spoken, and maybe they're not the most comfortable with public speaking, for example. How do you get them to feel prepared and to feel comfortable, speaking about what they witnessed or whatever it may be in relation to the case? How do you get them to feel comfortable speaking in front of the court and in front of the jury?
So that's something I do a lot in my work, and something I think I'm particularly good at. But the answer, I think, in general is this: that in order to make someone as comfortable as possible before they testify, it means spending time preparing them. And you need to get to know them and get to know the factual information that they're going to be conveying, and get their understanding from a number of different angles, how they understand the information that they're presenting. If there's documents involved, you need to look at those. You need to become familiar with them. So if they filled out records, or they're able to review somebody else's records, or some other kind of, what I've talked about before, primary documents, evidence, factual information, photographs, whatever it may be, you need to be very familiar with that information. It helps to be familiar with, if other people are testifying and have given information about the same subject, you should be familiar with that information. So if there are a number of witnesses purporting to describe their analysis of the same, or their eyewitness of the same fight or the same transaction or whatever, you should know what other people are saying about that transaction. You should know what the documents are saying. You should know what this person is saying. You should know what they have previously said about it. And those should be things you come into the sort of start with, if you can. And then in terms of getting them more comfortable to testify, what I will very frequently do is set up a mock trial kind of atmosphere. So I'll bring someone, and instead of sitting in a courtroom, we'll sit in a conference room, but I'll set it up with podiums, sometimes with people playing each role in the court. So someone playing another lawyer, someone playing the judge, and someone playing that person's lawyer, the person who's going to question them, and go through and practice the testimony and ask them the questions, see how they answer them. And then do practice cross-examination. Play the role, sort of make believe you're in the role of the other party that might be cross-examining them, or the judge, and do what you think the judge might do in a trial. And show the person, what it's like in the courtroom, and let them feel the tension of it. Let them try to answer questions and play it out in a role, while sort of playing in role. Learn how they react to questions and modify your questions, to improve and advise them, based on how they're reacting. And then in many instances, what I've found is that if you do this consistently, and I try to ask them tougher questions than I think they're going to get in the trial. Often when I'm doing playing a cross-examination doing a cross-examination in a mock trial scenario, I know more than the person who's going to be cross-examining them is likely to know.
True.
So I can ask them tougher questions.
Yeah.
And that go right to the heart of it, and they get if not comfortable, at least
prepared.
They've been through it before.
Yeah.
It's not the first time they're experiencing it. If there's an emotional response, it's sort of gotten out of them, and they've been given a chance to experience it once, and they get the feeling for it.
So they've sort of inoculated themselves to the potential stress that they might face during the cross-examination.
They've practiced it.
Yeah.
Like a lot of things, it improves with practice. Yeah. So even going through a stressful experience while people are watching you and staying focused, that's a skill that itself can be practiced and improved. And so that's what I try to do. I try to practice that and improve them. And like a lot of training, I try to create situations that are maybe at times more difficult than the actual situation will be, so that when they get in the actual situation, they feel like, oh, this is easy compared to what they've experienced in the practice.
Are there certain things that you do with a witness or whoever you might be bringing in to testify to? Are there certain things that you'll tell them, certain strategies to like make them more likable in certain ways to the jury? Or is it a pretty like rational approach, getting them to say it in the best possible way? Like, because I know, I was telling you, I just watched the movie 12 Angry Men, and so, obviously, we can speculate as to how realistic of a depiction of a jury that might be, but when they're sort of evaluating some of the witnesses, they were like, I don't trust her. She didn't, seem prepared. She didn't seem like she knew what she was saying. Or obviously other people were, had different opinions. But whatever. My point is, just from watching that, it sort of seemed like there's an element of like, how likable is the witness, or how likable is the person testifying? Like, do you feel like you need to like mold them in any way to get them to, make a good impression on the jurors, or is it just more so about what they're saying?
My emphasis or my focus or my technique, is not so much to mold the witness to be a different way than they were when they started. I'm more focused on finding out what's likable about the person and becoming familiar with that, so that there are people. And I would like to use a different adjective than likable. I sort of adopted your adjective. But I think oftentimes in a trial or in the presentation of witnesses, the issue is not so much likability as, and this is a little different if it's the plaintiff in a personal injury case, this is a little different. But for most witnesses, the issue is not so much likability, but credibility. And so that, when I'm preparing a witness, I'm looking to try to discover what it is, or why do I think they're credible, or what makes them credible, and emphasize that. So I'm not so much trying to change them as learn about them in detail, in great detail, and so that I understand what they're thinking and form a belief as to what they're telling the truth about and why it's convincing. And so they may be a real jerk, but sometimes a real jerk can be very believable. And so it's not to make them from being a jerk into being somebody likable, but to bring out the points in what they have to say that are...
So it's about making the jerk trustable rather than making the jerk a non-jerk, basically.
Right.
I see.
Right.
Interesting.
And that doesn't mean trusting them, making them trustable in the sense that you're asking the jury for a favor in trusting them, or you're asking for the fact finder a favor of trusting them, or putting your trust on the line and getting them to be trusted. It's not that kind of trustworthiness. It's the kind of trustworthiness that emerges organically from circumstances. That,
like, there's no way this guy didn't see what happened.
Right, whether I like him or not.
Yeah, he knows what he's saying. Yeah. Okay, that makes sense.
Because if somebody would know this part, they would also know this part. And he knows this part. And so if he knows this part, he must have known this part too. And that's different from likability.
Okay.
That's knowing the facts so well that you can bring out at the right moment the thing that makes it convincing.
Awesome. Yeah, that's a
and that comes from knowing your
distinction.
witness, from knowing the facts, from knowing the documents, from knowing the evidence.
I see.
It comes out of the preparation more than the magic of being persuasive. The magic of being persuasive is doing the homework.
Yeah, I see. What's the most niche thing you ever had to learn about for a case?
So the thing that stands out in response to this question is one of the first cases. When I first started practicing in 1994, I was asked to do some tasks on a particular case. And I worked on the case for a while, and then due to a variety of reasons, what the case involved is somebody's purchase of computer equipment that was very new equipment. So this purchases were being made in the late 80s, and they involved scanners and certain types of printing equipment and computers. These devices were only first coming onto the market at that time. And at that time, they cost, and this is in the late 1980s and some very early 1990s, it was computer, scanner, and related setups, related to that type of work could be cost more than $1 million for a setup like that. Something that 10 years later, Mac was making, for $10,000, and which can be purchased now for even cheaper than that. But at the time in the 1980s, these first devices came out, and they were hot items, and they cost over 7 figures to get this set up in your shop. Many of them printing shops down here in this neighborhood in Soho where we are now. And so I had a case that involved that. And so I started working in 1994, and I worked on that case a little bit. And then for a variety of reasons, that case was stopped. Didn't go away, but nothing happened in the case for a number of years. The person who was involved, the other side, went into bankruptcy, which resulted in a long period during which the case wasn't processed. And then after the bankruptcy was completed, it was a long period of time of just inattention before the case was resumed. So by the time the case was resumed, it was already the late 90s, early 2000s.
Okay.
The underlying computer purchases for 7 figures and more had been made in, say, 1989 to 1992. So when the trial case went to trial in early 2000s, the machines were 11 years out of date. And the field had changed so dramatically that not only were they outdated old machines, the current machinery that was doing the same task that people would get cost about less than 5% of what they cost back in 1989, and was completely different machinery. And so the client, who had been originally located in Nassau, in Long Island, servicing many businesses in downtown Manhattan, had been purchased by a German company or merged with a German company or whatever, and headquartered down to Atlanta, Georgia. Mm-hmm. And I went down to Atlanta, Georgia, to meet with the clients and prepare for the case. They had a museum down there of their equipment. So they had like a sort of archives where they held a museum, where they maintained a museum of their older equipment. And so I asked to be shown the equipment in the museum, and asked to be taken to the museum and shown the equipment there because I hadn't seen it. The answer I was given was, well, this stuff is so old and so supplanted that this stuff we don't even keep in the museum anymore, So I didn't even have examples to show me. But I did have the documentation, and I was able to get witnesses that were very familiar with the machinery at that time, who were salesmen and who were technicians and other people that had worked on it, but obviously weren't doing it anymore because then no one was using this machinery a decade later, or more. And in order to do the trial, the issue in the trial related to how did the machine, whether the machine was functioning right or whether it had been set up right, and a variety of other issues, related to that. In order to master the issues for that, I had to read all the documentation, all the manuals, and learn how this machinery worked, how it was configured, what parts went together with it. But all this machinery was all gone off the marketplace, was not being used anymore, and had no historical interest to anybody, particularly.
Just random technology that isn't used anymore.
For a brief period of time, yes, right, and was used for a brief period of time, but a great deal rested on the outcome of, whether it was working or had been set up correctly or whatever, with the result, and one of them there were two striking things that happened during that case. I'd spent so many day in and day out studying this material, and it involved a lot of volume of stuff that I had to master. And I remember one time speaking to one of the managers who was involved in this, who was also a witness, and I was pointing out different aspects of it and discussing different aspects. And he said, congratulations, you now know more than one of our salesmen, who was selling this equipment, at the time. Saying I could explain it better than that. And then during the actual trial, I was cross-examining the expert for the other side, presented someone who was an expert in this material, who didn't work for my client, but either previously did or worked for a rival corporation or whatever that was involved in the same marketplace at the same time. And during the cross-examination, I was asking these questions, and he said something. I said, "So if you did that, you would have to hook it up to this kind of a thing, though, wouldn't you? Because where would the input be, or where would the, I can't remember the exact question, but it was sort of right on point with being knowledgeable about this obscure stuff,
The guy's like, how'd you know that?
Well, the guy said, and I could still remember it very clearly. He said, "You really know a lot about this equipment for a layperson." He said to me in front of the jury, So that was very gratifying. But, as soon as we had the verdict in that trial, this information was best forgotten, as soon as possible,
Yeah, back into the cobwebs. Yeah.
Well, so that was, I think, there have been other examples, but that was a particularly striking one.
Okay, yeah, that's a funny story. So, what's the most serious case that you've been a part of?
So, I will start by disclaiming, or refusing to answer that by saying, they're all serious. And there's what someone said to me early in my career, there's no such thing as a small case, only a small lawyer. But, in order to indulge you, I will try and answer it. So early in my career, I was asked to assist with a case. And I worked at a small firm, 5 or 6 attorneys, at the time. And we were brought into a case that involved a lot of defendants, most of whom were represented by big firms, that were insurance companies that were being represented by major firms. However, our firm was a small firm, but had very, people with strong qualifications, and was viewed by this particular insurance company as a good alternative to the much more expensive big firms, and could get, good work out of a small boutique, So we got this, what was a great case, I guess, from, abstractly from a lawyer's perspective, in terms of representing an insurance company, they'll be able to pay, they have a complicated problem, an interesting case, so it seemed like a good case to get. And, the other people involved in it were big firms. So I was brought in to assist with this case, and what did the case involve? It involved, and there were a lot of important lessons for me in this case, but the client was an insurance company accused of, in the 1930s, selling life insurance to Jews living in Europe, with life insurance policies that only would pay out on presentment of a death certificate. So you buy a life insurance policy, with, say, you take your life savings and you buy a life insurance policy. And the life insurance policy says that on the presentation of my death certificate, my beneficiary will be paid X amount of money. right?
Yeah.
So they did this allegedly, knowing that many of the people they were specifically marketing to and taking their life savings were going to be deported to concentration camps and killed without the issuance of death certificates. And so that's what they were accused of doing.
Wait, why would they have done that? I'm sorry. Like, what was in it for them?
Well, they'd sell this life insurance policy to a prospective customer.
Yeah.
The customer, if it was $1 million life insurance, these were like denominated in European currencies, but if this was a $1 million life insurance company, maybe you have to pay $750,000 to get it. And when the way it's collected on is by presenting your death certificate. So your child or whoever you name as your heir could present your death certificate to the insurance company and collect $1 million. And you paid $750,000, which might have been your life savings, in order to get that right for your child or your spouse.
Who didn't ultimately get the money because of what was going on in Europe at the time.
And the insurance company allegedly knew that the people they were specifically undertook to market to people that were likely to be sent to death camps and who were going to be exterminated without death certificates, and so they would never have to pay out.
Jeez. So first of all, which side were you on?
Well, the insurance company hired us.
Well,
one of the many defendant insurance companies. There was a group of insurance companies that were defendants, and the different defendants had.
Yeah.
So you're asking what was the most serious case I worked on, and I'm trying to answer that. And so this was a serious case.
Yeah.
And I had a lot of misgivings about this, and I contemplated asking to be excused from it. Yeah. Wasn't really practical necessarily, because in the small firm I was working at, and this was an important case, an important client. I was the only associate at the firm at the time. So the idea that I would sort of beg off it, and I'm not saying it was impossible, but it was certainly uncomfortable, because there wasn't necessarily somebody to sub in, at the time. Well, so I was concerned about this. And I was sort of struggling with this, and this goes back to your question about representing someone who's guilty, and this was very early in my career, And what ended up happening in the case was this. First of all, the case, there was a dismissal motion pending in the case. The defendants made a motion to dismiss on the ground, I think, that was actually in the pure legal sense, and this also addresses some of your other questions. In the pure legal sense, it was a very convincing argument to say that this case ought to be dismissed because there's no jurisdiction, that if there was a remedy for this, it's not 6 decades or more later in the courts of another country. That this case was brought in the Southern District of New York, federal court here in Manhattan, that if there was a remedy for this, that it's not in the Southern District of Manhattan in the 1990s over something that happened 60 or 70 years ago in Europe, it's the wrong court. And so either the statute of limitations over, or, meaning it's too late, and there isn't any real explanation why it wasn't brought 20 years ago.
Yeah.
Nobody thought of it, Happened to be one of the lead counsel on the plaintiff side was my evidence professor from NYU Law School. So there was a good, very convincing dismissal motion pending. However, which probably could have been decided very quickly just on the pure legal merits. But the judge just refused to decide it. And it sat around endlessly because my own view is that the judge didn't want to be the one to dismiss these Holocaust plaintiffs. And the judge wanted a settlement to happen. And so we're working on the case. I'm distressed about it, but sort of privately distressed, still working on it. So while all that's happening, the insurance company we're representing conducts an investigation with respect to the plaintiff in the case. It was a class action case, so there was like a representative plaintiff representing all the people in the category of people that this had applied to. And so this person there was a representative plaintiff who bought an insurance policy from the company we were representing. Our client did an investigation of their archives which took some time, and eventually they came up with proof that that policy had been paid. So after that, I looked at the whole thing in a different way, because they had a complete defense to this.
Yeah, interesting.
At least to that one plaintiff. So what ended up happening is that happened. I looked at the situation in a whole different way. Eventually, this was brought to the attention of the plaintiff's attorney. That plaintiff withdrew, but they found another plaintiff who claimed that they bought an insurance policy and wasn't paid, and our client continued in the case, but they had to substitute in a different plaintiff. But again, they had to substitute in a different plaintiff because the thing they were alleging that turned out not to be true, and that the insurance company didn't do the thing that was claimed in the case and was innocent of those, it wasn't a criminal case, but they were, to adopt the language of a criminal case, they were innocent of those charges.
Yeah.
And so it did turn out that whatever your attitude about or your preconceived notions about defending someone who may have been involved in negative things that occurred during the Holocaust, these specific people had a complete defense to it.
Yeah.
And so that really changed my attitude, or reminded me why I was there in the first place, put it that way, and changed my attitude about it, and sort of something I look back at throughout my career as a reminder, as to why people need a defense, even when they're accused of serious things or things that are immoral. Eventually, the judge never decided the dismissal motion. Instead, the case settled, and it was then Senator Alphonse D'Amato, who, while I don't believe he was really technically involved in the case, sort of intervened and personally showed up and pressured everyone to settle, and it resulted in a sizable settlement for the plaintiffs. And that's how that case ended up resolved.
It's a cool story. It's interesting that you look back on that. I was gonna chime in there, but you sort of answered the question. But it's interesting that you look back as a reminder of sometimes if you're uncomfortable defending someone, and maybe there's convincing evidence that they've done something wrong, there are still opportunities in which things change, and maybe you can never be too sure, and regardless, they deserve the best defense, and you should bring that to the court.
So this occurred in my career 25 to 30 years ago, the story I just described, and I can still remember it quite clearly, and still it influences my decision-making years later.
Wow. So transitioning into some of the more personal questions that I had for you, you're someone who reads a lot. Why? Why do you love to read so much? There's good answers and there's sort of superficial answers. But I think the superficial answer, which may be, as important as any other one, is that I like reading. I enjoy it. It's informative. I just enjoy it. That's, so I'm, as you point out, a voracious reader, but I think, that's the main reason, the one that I just gave. But the other part of it is, I think that the world's a complicated place, and to really understand the arguments about it, and again, it also depends on your learning style and a variety of other things, but I think arguments and viewpoints are complicated enough that they're hard to set forth and explain in presentation short of a book-length argument about something. So I think that it's a great way to get across complicated ideas and complicated arguments and educate people that's not quite matched by other written formats or podcasts or whatever, all of which play a valuable role, but not to the complete exclusion of books. I think a lot of the best learning is still done in books, despite all the different possible ways, at least for me. Okay. Yeah, I mean, I've sort of been wondering this myself, because I'm someone who's I really like to read, but I'm an extremely slow reader. So do you think, let's say in my case, is it is it worth devoting, a lot of extra time to reading, or do you think like I could get all of the benefits that I would have gotten from reading through just, or maybe reading shorter articles, but also, going on the internet, watching videos about stuff, watching lectures about stuff, maybe because I know you were saying that books have more of you can't really communicate all the things that books communicate through, whatever I just named, but perhaps if I did those things, lectures, podcasts, whatever, more diligently, do you think I could make up for the difference there? Or do you think that ultimately when you read, you can portray, more information and really tackle more complicated nuances that couldn't really be tackled elsewhere? Like, talk about, ultimately, I'm just curious to hear your thoughts on the conversation as to whether extracting valuable ideas and information needs to be reading, or can people theoretically get that through other means of learning?
Well, I'll start off by saying, questioning a little bit a sort of premise of your question, at least with respect to you personally, while you may perceive yourself to be a quote-unquote slow reader, my guess is that given your educational background and achievements, that you're a very capable reader, despite your perception of it. But in answer to your other part of your question, or answering your question for the first time, having questioned the premises of it, I think that different people have different learning styles and are receptive to different ways of receiving information. And I think for some people, they're not receptive, or they're resistant to taking in the information via book-length treatment of whatever it is.
700 pages.
With the result that that them trying to sort of do that is unlikely to be productive, or is unlikely to be as productive as other methods that they find they're more receptive to. So I think that's a big factor in what learning method is likely to be successful, is what method you're receptive to. So even if there, in theory, might be some better way,
if it doesn't work for you,
it doesn't work. And so that's sort of my first point on it. So particularly if you're sort of studying things for pleasure, I think you may have to go with the methods you're most comfortable with as likely to be the most effective. That's one. But two, I sort of stick to my previous answer to the previous question. I think that some things are hard to get across in other formats and are best explained in book-length treatment. I also think that many people who have struggled with books have nonetheless, or specific books have nonetheless gotten a lot out of them. So I think it can be deceptive sometimes, where it's a struggle and it seems difficult or tedious, but that once the book is read and completed, you could be surprised of what you got from it, even when it didn't feel like it as you were going through.
Do you have any examples of that happening in your life? Like books that while you were reading it, you were like confused by, and then when you finished it, you were like, maybe I did get more out of this than I thought.
I could name two, that sort of come into that category. And one is that Wittgenstein book that I mentioned before, a lot of which is written in a form of symbolism, a notational presentation of logic in almost like almost similar to a mathematics notation combined with prose. And I find I struggle with that, so what I've read that book numerous times, there's definitely parts I still cannot follow, but at the same time, I feel I've gotten something valuable from it. So it's a mixed experience with that book, and remains so. And that's including after having read sometimes substantial commentaries purporting to explain the parts that many people struggle with.
Mm-hmm.
that's one example. Another example that's I had the experience and is frequently thought to fall in this rubric as well. That first book, I'm not the only one that had that sort of experience with that first book. And this second book, the same thing, which was a book by Hyman Minsky, who was a famous economist describing the nature of the business cycle and the modern economy, the modern regulated economy involving large-scale financing, federal economic regulation, or regulators, regulating the operation of large companies and banks, and how the business cycle operates and what drives it, and how it can be addressed or tamed a little bit. He wrote a book about this subject, which was much discussed, which was a much discussed book, and thought to be very influential, but also cryptic and hard to understand, but was discussed at great length, was thought to have been very insightful and predictive with respect to the 2008 financial crisis in this country. I studied that book, or I read that book, and found parts of it I could understand, parts of it very confusing. But that was another example of a book that I struggled with and feel I didn't totally understand, but still feel I got something valuable out of, and was an important book and worth reading.
What's your favorite genre to read, and why?
I have a lot of interests. I've studied a lot of different subjects, juggling, transportation, behavioral economics, history of finance, Bible stories, so I have gone from topic to topic: American history, philosophy, other areas in economics. And so I have a lot of things I'm interested in. Since the recent war in the Middle East, I started reinvigorated my interest in reading about Israeli history, and I have been reading several books, and I've read some in the past, but I have been reading several books about the Israeli history, and I'm sort of in a study of that, at the moment.
So you are an incredibly knowledgeable person on current events. Speak about the importance of, being well-informed on what's going on in the world. Like, why is it so important for people to be well-informed citizens and people who are aware of current events and what's going on?
Well, for my own part, I like being well-informed. I find it interesting, so there's one part of it. But another part of it is, I think, just to go back to something John Rawls said, doing the right thing, can be hard. It's not necessarily easy. And part of it is knowing what's going on around you, to make a judgment about what the right thing, how to behave and how to lead a good life. Part of that is knowing what's going on in the world, I think. And be a responsible citizen and responsible voter. I think knowing what's going on in American politics and international affairs, these are, I think, very important in order to make intelligent choices at the ballot box and participate in American democracy. And so I think I would like to see America have a more informed citizenry, and I would like to be well informed myself.
Yeah. Well, that definitely makes a lot of sense. But just to play devil's advocate, like, what about someone who, is working all day to, make ends meet and trying to support their family? Like, should someone like that take the time to, educate themselves on what's going on in the world? Or what are your thoughts on that instance?
I certainly don't begrudge anybody who's struggling to take care of their family or their children or meet other crises, from focusing on those things, if that's what's most important in their life, at a particular time. I certainly don't begrudge anybody that. But having said that, I think throughout history and around the world today, there are plenty of people that are poor, that are struggling, that still are politically aware and have political viewpoints. And as much as you might want to at times be, as much as you may be distracted by other more seemingly urgent things in your life, there comes a time when very often in people's lives, whatever else is going on, when they're forced to make political choices. And it's only by arming themselves with some information about the choices they have to make that they're likely to make choices that they, that are likely to be helpful for them and promote their own interests even. And so I think, while the premise of your question seems to assume that there's whole categories of people, that have no way of becoming politically aware or educating themselves, I think that there's that may apply to some people, but there's many people that have a lot of struggles in their life that nonetheless
take the time and find pockets out of their day to educate themselves on what's going on in the world, basically, regardless of the fact that they might be struggling. I mean, I think it's interesting you point out that there are people who have those struggles, but they're living proof that even people in pretty dire, hard circumstances still make the time to educate themselves on what's going on in the world. It's definitely
and it may happen in ways that are more direct than the way you perceive educating themselves. If there's a policy with respect to taxation of salt, and you need salt to live, you're going to learn about that policy whether you like it or not.
Yeah. Interesting. All right, well, that's all the questions. We've been going for 95 minutes, so that definitely will more than suffice.